In Texas, what is the difference between a ladybird deed and a transfer on death deed? I'm going to start this video by saying I am not licensed in Texas. So if you are in Texas and you have the option of using either a ladybird deed or a transfer on death deed, it is very important that you consult with a licensed Texas attorney. Depending on the use of the deed, there should be an estate planning attorney who also practices elder law, or possibly a real estate attorney, but I'm going to say you probably want an elder law attorney, someone who practices both estate law and estate planning law and elder law to answer this question. However, I'm going to tell you what my understanding is in this video. Again, this needs to be double checked with a licensed Texas attorney. So for one, it is my understanding that a transfer on death deed in Texas would potentially have a 2-year clawback period, meaning creditors of the estate or a personal representative, an executor, could potentially claw back portions of what was transferred in order to pay the estate's debts. So maybe the full property doesn't end up getting transferred to the beneficiaries. Another important distinction that doesn't happen in a ladybird deed, by the way, another important distinction is the ladybird deed allows you to transfer with warranties, so meaning the warranty of title can get transferred with it. With that, it's the hope that the beneficiary can enjoy the same title policy that was bought for the home, whereas a transfer on death deed cannot be transferred with warranties. Some of the more common ones are, and this could be in other states than just Texas, is a ladybird deed can be signed by the homeowner themselves. It can also be signed by an agent under a power of attorney. So if an agent has a valid power of attorney allowing them to execute a ladybird deed on behalf of the owner, another individual can execute a ladybird deed. Doesn't have to be the owner. This could be really important if it's being done for Medicaid qualification purposes, or maybe somebody is in the process of dying and it doesn't have capacity to sign the deed but wants it to be transferred to their children to avoid probate. You can do this with a ladybird deed, whereas a transfer on death deed, it's the owner that has to sign the deed. Also, for transfer on death deeds, it is required for them to be recorded in order to be valid. So the transfer on death deed has to be recorded before the person passes away in order for it to be a valid instrument. Again, this should be double checked with an attorney in Texas. In Florida, we don't utilize transfer on death deeds. We do, however, utilize ladybird deeds. So I'm aware of the many pros that they can offer to people in Florida who are wanting to transfer their real estate outside of probate or maybe for Medicaid purposes. But essentially, both of these deeds do operate in the sense that it's a way to name a beneficiary on your property, somebody who wouldn't have a current interest in your property but would gain that interest or that ownership right after your death. But they are different despite what might be out there. So it is important to speak to an attorney located where you are in the state that you live in, so you can learn the pros and the cons or the differences between the deeds, and so you can decide which one is best for you. So I hope this helps to answer the question, and if you have any other questions about ladybird deeds, estate planning, or probate, and you're in Florida, please don't hesitate to contact our office at Cause Law Office, the non-stuffy attorneys, and the link is in my bio.